Well, hello and good day or good evening or good morning, wherever in the world you might be. Today is September 7th, and welcome to We'll Work for Food, the New Possibilities Hour. Today, we've got a great program for you, how court-appointed neutrals can help courts. And I'm sure there'll be lots that we'll learn. But before we get going, as those of you who are regulars know, this program was started in the spring of 2020 by Natalie Armstrong Motan every Thursday, other than Christmas and Thanksgiving. Jeff Kitchaven and I co-moderate these various programs. We've had amazing speakers, and we're more than 3 years in now. That's a lot of presentations, and those are mostly all recorded. You can go back and view recordings, and I would encourage you to do so. But ultimately, there's no charge for these, and that is the purpose of these programs, is to raise money for food banks around the world. And we have literally, our generous audiences, our generous speakers, presenters, have in fact done that. Natalie, how much is it that we know about in donations? And I always put an asterisk on that because certainly everybody doesn't tell us what they've donated.
So thank you very much, Jean. Normally, people send me or they forward me the receipt of a donation that they've made to a food bank, or they let me know in the chat that they've made a donation to a food bank. And then I sort of keep a running total. Of course, not all donations get reported to me, like you said, but of those that we're aware, as of today's date, we have $440,015.98 noted here in my fancy dancy journal book where I keep the running total going. Our audience, our presenters have been so incredibly generous. Thank you all so much for all that you do.
Yes, thank you so much. That's amazing. We're coming up on $500,000. I can see it so soon. That's just amazing. And so that's probably about 4.5 million meals, depending on how the buying power is, how good or what would I say, the buying power of the particular food bank. And so with that in mind, let's get to today's presentation. And we have two amazing speakers for us, Merril Hirsh and Janice Sperow, who I know Janice has been here throughout from the beginning, one of our regular attendees and participants. So why don't I turn it over to the two of you, and if you would both mention your food banks, which I understand that you've suggested to be Katrina's Club or Martha's Table. And Natalie will put those links in the chat for everyone. And we look forward to the program, learning all about court-appointed neutrals and programs. Thanks so much. The floor is yours.
Hi, everyone. And I apologize for being a couple of seconds late there. I had technical difficulties. Zoom decided that it was the time to update at the moment that I was trying to click on. So please forgive me. As we get started on this topic, Merril, I want to just ask you to get us all on the same page. What is a court-appointed neutral exactly? What are we talking about here?
Sure, I'll talk about that. But first of all, let me introduce you so people know who you are and our food banks. I'll start with my food bank, which is Martha's Table. I live in Washington, D.C., and Martha's Table is just a terrific place. They do meals for people and have volunteers, and my family and I have volunteered there. You go out and deliver meals to homeless people in D.C., and it's a wonderful organization. And Janice, do you want to introduce your food bank?
Yes, Katrina's Club is actually started by a restaurateur during COVID, who, because his restaurant was closed down, made a bunch of meals for kids that didn't have kitchens because they were living in hotels. And so it basically is helping children in need with food insecurity. And one of the very first speakers we had on this program, which is a phenomenal program, and I can't say how much I admire Natalie and Jean and Jeff and the whole crew, actually put that as their original donation suggestion. And I was so moved by the speaker, it was an appellate attorney, that I donated. And then I got into finding out more about it and thought, wow, this is a really worthwhile cause. So I adopted it as my own. Anyway, Merril is, in case for those of you who don't know, executive director of the Academy of Court-Appointed Neutrals, himself a distinguished attorney, arbitrator, mediator, all of the above, as he mentioned, based in DC. But he's also the brainchild behind really reaching out into the community and trying to make what court-appointed neutrals used to be kind of an old boys network much more of an inclusive, open, diverse, welcoming environment so that everybody can have a chance to be a part of helping the court. So I give him extreme kudos.
Thank you, Janice. Janice, as you probably all know, has only been in 1,000 arbitrations and conducted 550 or so of them herself. And one of the most remarkable things is that she managed to overcome merely being magna cum laude at UC Berkeley to get buckled down and be summa cum laude when she graduated from law school at what was then Hastings. And she is a force of nature, former partner at Morrison Foerster, managing partner of her own law firm, and former president of the National Association of Women Lawyers. And we could occupy it with more Janice stuff. But, and also one of the sweetest people who any of us ever met. And Natalie and I were exchanging stories when we were talking beforehand. So, all right, finally, I will get to your question I've been evading, which is, what is a court-appointed neutral? A court-appointed neutral is the name we are trying to use to rebrand a profession. Most commonly, people have referred to this job as special master or master. And one of the things we have been working to do, we meaning both the Academy, which used to be the Academy of Court-Appointed Masters, and the American Bar Association and the National Association of Women Judges, and others who are trying to get to sign on, including the ADR community, is to recognize that the name master is a really lousy name. I mean, in addition to having such obvious negative connotations to using the term master and having a court appoint someone in a position of authority to serve as a master, it very, very poorly describes a profession because it suggests that someone brought in to take over when the job is someone brought in to help. In a court-appointed setting, and actually these neutrals can be appointed in other settings like arbitrations, or the 9/11 fund that people are familiar with was a legislative matter, not a court appointment, or administratively. But basically, we're talking about a Swiss Army. We're talking about a tool that in this setting, courts can use to advance the administration of justice, to make it fairer, to make it less expensive, and use creatively to increase access to justice to unrepresented litigants or people who couldn't participate otherwise, or to reduce the expenses so we open court doors to more people. The most common example that people think of is the judge who's pulling his or her hair out in frustration at the parties who have filed 4 million discovery motions and they're arguing back and forth. And the judge just says to them, look, I'm sick of you people. I'm going to send you to your mother. I mean, a neutral, somebody, right, to handle this stuff. But it isn't just that. It could be people brought in not necessarily to adjudicate, but to facilitate, to help the parties work out these problems so they don't lead to motions in the first place, or to bring in expertise, a forensic accountant to help people figure out where the money went from a trust, or an engineer to help the judge figure out what's junk science, or, you know, a biochemist to help interpret terms in a patent, or someone to monitor a decree and make sure that it's being implemented, or to help do claims administration as part of a settlement, or basically anything that might be of use to the court to assist in litigation. So that's what we're talking about. So Janice, why do we need these things, these people?
Well, you'd think we wouldn't, that we have a fantastic state and federal court system and that, you know, they would handle it. But the reality is our judiciary is swamped, completely overwhelmed. Let me give you a couple examples just from California here. And I know we have folks from all over, but California is a pretty busy state. And so this should be pretty indicative of where the other big hotbeds are. So I'll give you an example, Los Angeles. They have roughly 600 judges. So you would think they got 600 judges, they've got it covered. Well, even though they have 600 judges, each one of those 600 judges has on average 700 cases. Now, go down south to where I am in San Diego, and it gets worse. We have 125 judges with 1,500 cases per judge. 1,500. Needless to say, we're still plowing out from underneath down here. All the, you talk about COVID as though it was, eons ago and everybody's back full steam. Well, that's not 100% true with 125 judges who have 1,500 cases on average each. So that's why we need them. And if you want to put it in kind of more lofty, big picture terms, we've all heard the famous saying from the justice delayed is justice denied. If each one of these judges is backlogged to the point that they're not getting to matters because they simply don't have enough hours in the day, then somebody's not getting heard. Somebody's not getting access. And the idea that court-appointed neutral can step in where appropriate and help out is I think, an amazing concept. The federal courts do have magistrates that can do a lot. They're swamped too, to be honest. And the state courts don't have that. The state court doesn't even have a magistrate. So the state courts are in particular need of all of your help, frankly. I could go on and on actually, because I'm, shy and retiring and never talk, but I'm gonna try to move us through a little bit faster than that and ask, so what do they actually do, Merril? I mean, okay, we know what they are. We know why they're needed. What are the kinds of things that they do? You've mentioned a couple. Give us a few more examples of what tasks they can perform for a judge or for the court.
Sure. And let me sort of separate out two things, what they have done historically and what they could do going forward, because those are both worth thinking about. Historically, they get involved in complex cases. The most common situation where they get used in court is one of two. It's either the MDL type setting, and understand they're used in really interesting ways in multi-district litigation. Multi-district litigation represents about half of the federal caseload. So it's a big part of federal courts, although recognize the vast majority of cases in America are in state court, not in federal court. But they get used in unusual ways. You have the traditional sort of, okay, deal with the discovery issues, help facilitate that, help work that out. Often they'll have another person who's on the settlement track, because everyone's anticipating the case will discuss settlement. From the outset, they may have someone appointed on the settlement track, and they may work with different teams, and they may exchange their own information based on not what do you need to bring this, to get this case work together for a summary judgment motion, or if it gets transferred back to try the case, but what do you all need to know to make intelligent decisions about settlement? Could we bring in experts, or could the person neutral be an expert, say, in figuring out damages to help people work through whether the claim is worth proceeding with it all, or if the claim is such a big risk that it's worth settling quickly. So they can use creative ways to try to deal with claims in a different way. As Janice has talked about, although they're more used in federal court, they're really more needed in state court because the state court dockets are just so staggering. There are 30 million cases filed in the United States each year, and 400,000 of them are in federal court. So you can think of those numbers. They can be used in criminal cases too. Court-appointed neutrals have done things like gone with law enforcement who are executing a warrant of a law office to make sure that they don't see attorney-client information when they execute the warrant. or to do reviews of Brady disclosures by the government, rather than have the government appoint their own team or their own group to second guess themselves, get an independent person. Part of the advantage of that is you get the integrity of having this done by a neutral, so that if people are concerned about it, you can have somebody independent brought in. They just had a case this week involving the Supreme Court's remand of the Alabama redistricting plan, where the judge concluded that Alabama had not done what the Supreme Court told them to do. And the judge said, okay, I'm going to appoint a neutral to come up with a redistricting plan for Alabama that's independent of both the Republicans and the Democrats, so that we can look at something that's done independent of, of the politics involved. But part of what, and I know I'm turning on a little bit, but part of what I'm particularly excited about is recognize the problem of our time in state court is unrepresented litigants. 75% of the litigants who come to state court are unrepresented. And as Brittany Kaufman, who runs a wonderful organization, ISLES in Denver, pointed out in a program where I saw her, this is a problem lawyers don't see, because lawyers are in the cases with other lawyers, and they don't realize that the biggest problem court has is, how do you deal with this many litigants who aren't represented by lawyers? How do you get them justice without unethically helping them to handle their cases, which you can't. You can't be biased in favor of someone just because they're unrepresented. If you could set up programs to involve neutrals, A, to make it less expensive and more possible to do it, and B, to help solve that problem, we would be doing the greatest contribution we could possibly do to the state court system, I think. So that's a long answer, but I hope it's helpful. So, Janice, okay, they're all great, they're all wonderful. What should a court consider in appointing one of these neutrals?
Well, I think the bottom line is a lot of different tasks can be done by a court neutral, but one of the main factors is anytime you have a time-intensive fact or time-intensive task, that's ripe for a court neutral, because the court simply does not have the time to devote to an intensive inquiry. For example, findings of fact, investigation. What if it requires intense data scrutiny? I mean, we've seen the rise in breach of privacy and data breach cases. How is a court going to start looking at code, metadata, and other different computer systems and cyber systems to determine if there was a breach of a massive amount of consumers on this scale of 75,000 T-Mobile users or something, right? They don't have time for that. That's a perfect example of when a court neutral would be extremely helpful. Class action situations, just claim submission, notice to the class, determining who the members are, consent decree compliance, anything that requires some kind of monitoring or time-intensive task. Merril started with this, but honestly, a lot of the ones I've been involved in and know about is just plain old babysitting, really unruly counsel. I mean, we both have a colleague in very respected court neutral in Denver, who literally the parties want to pay him to sit in on their depositions just so they can have an orderly deposition. Now, that's a little extreme. Most of us are bigger adults than that, but that just gives you the range. I mean, it can be anything from, hugely complicated mass, MDL multi-district litigation to basic deposition conduct monitoring and everything in between. Now, when the court does consider they have a time-intensive task in front of them, Merril, what do they need to address? I mean, there's a formal appointment process. What do they have to address in that process to make it a valid appointment?
Okay, well, let me address again the way it works now and the way it may work in the future a little bit with some minor differences. The the federal rule of civil procedure that addresses the appointment of neutrals, and it still says master, but as I'll explain in a minute, we're trying to change that. It is Rule 53, and it has a number of specifications about what the order should contain. And it requires a written order of reference, and it requires that the order describe what the neutral is going to do. And includes usually some general language about, you have the general ability to make, to implement this, so that the court doesn't say, well, you have to have hearings on, it doesn't have to specify that the hearings need to be on Tuesday. It talks about the communications between the neutral and others. There are cases in which it's appropriate to have ex parte communications between the judge and the neutral, or people have found it so. They're appropriate when there are cases in which the neutral is in a facilitative capacity where it's appropriate to have caucuses and have ex parte communications with some of the parties. But the important thing is that this be considered as part of the order. There are also the specifying the duties, specifying what they will do on reviewing evidence, specifying the standard of review. The way Rule 53 works is there's a default standard, which is de novo for law, de novo for fact, and abuse of discretion for procedural matters. But the parties can agree to change that standard, and often it's very useful. If you're appointing a neutral to deal with discovery matters, the idea of and they need to do an evidentiary hearing, say to determine privilege or to determine the burden involved or determine spoliation, to have it say, okay, we're done, first try, now we redo it, and the judge is wildly inefficient. So there are various provisions that lay this out. And if you want a good place that tells you what all of these things are, a shameless plug, ACAN has a bench book that's publicly available on its website, and I can put a link to it. It has, what should this order contain? What's your checklist? Now, let me talk about the future. The ABA adopted 2 resolutions a month ago. In fact, a month ago today, at its annual meeting in Denver. One of these resolutions, as I mentioned before, put the ABA in back of, said, rulemakers, legislatures, you should stop using neutral or you should start using neutral or court-appointed neutral and stop using master or special master. The other resolution adopted a draft model rule for states, localities, territorial courts, and tribal courts that lays out not only kind of the thinking of Rule 53 before it, but attempts to advance it. Rule 53 was written in 2003, and there's been a lot of work on what might improve this. So the model rule is not something I anticipate anybody is going to adopt beginning to end, but it is kind of the best statement about how to answer these and tweak some of these things that are in Rule 53, based on both experience and making it more useful, and includes things that structure the selection in a way that gives stakeholders, the litigants, more comfort about the way the selection is done, that it ought to be done, and that it's done properly. So, Janice, that solves everything in the world, right? What else could there possibly be that we should consider?
Well, it's never happened before that California goes its own way, right? Yes, California has an entire different set of rules. It does follow the general federal parameters, but it has its own lingo, which I find narrow. For example, they don't call it special master, but they typically refer to it as a discovery referee or referee. To me, that's very narrow, because this is not just a discovery referee. You, as a court-appointed neutral, can play, as we've already discussed, any multitude of roles. So what does California do different? One of the key things that I have found to be very important is that California requires the special master court-appointed neutral to maintain records to the same extent as though they were the court. That means that if you are writing a report, receiving documents, submissions from the parties, which of course you will be, then you need to maintain those publicly, transparently available, just as a court would. Now, you might think, oh my God, what am I going to do? But the easiest way to do that is once you have, I mean, obviously not drafts, but once you have your final report, I just simply attach as exhibits to my report all the submissions that everybody submitted to me and lodge that formally with the clerk, with the court, so that anybody looking at the public file, unless it's under seal or confidentiality provision, anybody can look that up. One of the things that you won't find, and Merle already referenced this a little bit, is the State Bar of California has a list of, and they still do call them special masters, so forgive me, a list of special masters who are qualified to accompany law enforcement. And Merle already talked about that. I actually am on that list and have done that. And I have to say, of all the things I do, which I find exciting, the one thing my kids have thought were super, super exciting was that, wait, you went with the FBI to investigate? And I'm like, well, no, I didn't investigate. I was looking at documents. But you were with the FBI. So I got all excited about it. My point is, somebody has to protect the privilege. Somebody has to protect medical records if there's psychiatric records or something like that that's not germane and not waived. And that's what a special master, and they do call them special masters, does for the State Bar of California. And it's a list that's anybody in law enforcement in your area can call upon you. And the important thing about that is you still have to keep a record, because by statute in California, you have to keep a record, but you can't submit the privileged stuff, obviously. So you kind of have to find your way between being as transparent as possible, satisfying your statutory duty, but still maintaining the privilege that you were basically sworn to accompany them to protect in the first place. The other thing that California does, which is a little bit different, is there has to be a finding of, quote, exceptional circumstances for the court to appoint a neutral. Now, between us chickens, they call exceptional circumstances. That sounds like it really should be exceptional, but no, in fact, they decide that it's exceptional anytime it would draw the court's attention away from its docket, which we wish that was exceptional, but it's not. It's every single day. Multiple issues have to be resolved. That's one example. Multiple motions must be heard at the same time. That's another example. A single discovery motion needs to be heard, but it's understood that that's going to be one in a sequence of discovery motions. That's another example. These are all things that the court has said has qualified as appropriate exceptional circumstances. The number of documents to be reviewed would require an enormous amount of the court's time, and the court can't do that. Those are perfect examples. Another thing that California does is you are required to state in your appointment orders a maximum hourly rate. And if the parties request it, you have to add a maximum number of hours to be spent on the project. I typically offer that whether the parties request it or not, because I find that if I say, here's how much time it's going to take, one, they tend to not want to do that, so they'll get along more and use me more diligently, but then they won't complain when they get a bill for that many hours because I warned them in advance that that's what it was going to be. And then you always, of course, can go back and ask for additional time if the matter warrants it. Almost always what happens is you have 1 or 2 discovery motions, if that's what you're doing, and then 2 months later, here's a bunch more. They don't want to basically indoctrinate a whole brand new neutral. They want to go back to the same person who already knows the case, who's already ruled, who already knows what the squabbles are. And so then they'll just extend the appointment and usually also then increase the cap on the hours. One of the other things I think, and Merrill's being extremely modest, he mentioned the ACAN bench book, but the ACAN bench book goes beyond a bench book. A bench book is a guide. What ACAN has actually put together is literal templates. Obviously, you have to modify them to fit your circumstances, your jurisdiction, your court, your duties. But they basically have Word document type templates that you can use to build an assignment and provide it to your judge. And let's be honest, you as a special master / court appointed neutral are going to be the one who should be at least taking a first crack at drafting that appointment order, because the whole point is the judge doesn't have time to deal with the problem. So you can't say, oh, yes, I want to help you, but first you have to write a 20-page appointment assignment. No, you're going to make sure that you have everything in there that you need. The ethical rules under California Canon 6 apply. You have to follow, as a court-appointed neutral, the judicial ethics canons. So it's like you're not a judge, obviously, but you're stepping into that role, and you have to be sure that you know what those are and that you're doing it. California also requires time parameters. Now, it's not hard and fast. It's not like, okay, you say I'll be done by October 1 and then you're not. But you try to give a foreseeable schedule by when you're going to have these submissions, and then you're going to have the next round, and then you're going to have your recommendation. And your report is always a recommendation to the court, who then has to approve it. The court has the ultimate say, which is good, because at that point it becomes an order of the court, not just your say so, and the parties get into trouble if they start ignoring it. You do have immunity as though you were a judicial officer, which is a good thing. And basically you have to make sure that whatever you're doing is provided public access. And that's the one thing that I have found challenging sometimes in California. You know, I want to just do this in a conference room and let's just get this done. But if it's not a mediation, if it's not settlement talks, you have to provide a public access to it, just like it was in the courtroom, because they don't want things moving from the courtroom where people can come and watch to a private conference room. So you have to make sure that notice is posted and people know where the transparency is. All right, as usual, I'm just talking on and on, but let me ask Merril this. What are some of the types of cases in which the court-appointed neutrals can be helpful? I mean, we've talked about some of the tasks they can do, but like, name cases. Who has been using this and who can use this?
The great thing about these kinds of discussions is you know, think of the question as being, who could make use of ADR in some way in a court proceeding? You know, is a good way to think about it. And the more creatively, really, it's only limited by your imagination. That doesn't mean this is appropriate for every case. It's not. And recognize that the one question I always get asked, who pays for this? By and large, the parties pay for it. So one of the things the model rule contemplates is that the court is going to determine that the benefit of this outweighs the costs, which they should do, because it needs to be a transparent process. And to work effectively, people need to be an honest broker. You know, the appointment needs to be perceived as an honest broker. So it needs to be worthwhile that the parties are actually achieving something by this whole process, and it's chosen in a way that the person's chosen in a way that gives it credibility. We push very much for setting up rosters for that reason, and several others. But some of the things that stretch your imagination, I mean, you know, the construction defect. Okay, that's a really good example. And construction, you know, anybody in ADR knows that construction is the low-hanging fruit of ADR. You know, that people in construction recognize, gosh, we have repeat players. We are constantly arguing with each other over something. We cannot spend our entire lives in court doing nothing and never building anything. So we have to come up with some system that is going to work, recognizing that we want a continuing relationship with other people. So all of those factors move quickly into it, coupled with the fact that it's an area of technical knowledge. There was a program for a while in some of the counties surrounding San Francisco. They had a bunch of houses. They had similar sorts of problems. They were all built X number of years ago. They all seem to have X kind of problems. They set up a group of people who knew construction, who sat down with the parties and said, okay, we all know the drill in these cases, right? You know, you're going to need to exchange this, and this to figure out who's responsible, what the damage is, and how people are going to pay. So let's do it. And it took enormous burden off the courts in those counties to deal with this common problem. Obviously, mass torts, I mean, things that require in-depth factual analysis, fraud investigations, appointing someone to figure out spoliation. Spoliation is a really important issue for a court. It is very fact intensive, and what a pain in the neck to stop everything you're doing as a court and investigate how things came to be destroyed, right? So having someone do that kind of factual investigation. In DC, they have an office of the auditor master. Again, we should get them to change the name, but it's part of probate. Because courts were, okay, the money has gone from a trust. How can we figure this out? Let's have someone who is an accountant who has subpoena power in that circumstance and can bring people in and issue a report saying, here's what happened, which greatly saves the time of the court and facilitates it. Obviously, discovery disputes. Cases involving multiple parties. One of the most creative uses of neutrals is they have appointed neutrals to deal with internecine fights among the plaintiff's lawyers and the defense lawyers. And think about this. A judge can't step in the middle of that. Of course, they can't just talk to the plaintiff side or the defense side. And this brings out an aspect of it. By and large, people, I think mistakenly, think of this as some form of outsourcing, that basically this is something a court could do, but the court doesn't want to do. And that leads to the idea that we're privatizing justice, we're making it expensive, and it's just lazy judges, and there is a perception of it. The thing is, that's not really what we're talking about. To begin with, to the extent that neutrals do things that a trial or magistrate judge can do, it's also a question of whether it's something they should do. The 2015 amendments to the federal rules contemplated that the parties are going to be themselves responsible for securing the just, speedy, and inexpensive resolution of every action. Great words, right? And we all know that since 2015, no lawyer has ever delayed an action, made it more expensive, dragged it out, created any problem whatsoever, because that rule solved the problem. Well, of course it didn't solve the problem, because the rule's not self-executing, and telling lawyers, look, you should defend your client zealously within the bounds of law, just not too much, is a limited effect as a message. Helping them by changing the incentives is something judges are not in a great position to do. You could have a neutral solve a problem like using ADR in a different way than a judge can. The neutral can say, look, send me the discovery when you exchange it. Courts actually did that when I started practicing. They stopped it about the time I started in '82, but they actually had them file it. I don't know what the clerk's office did with all this discovery, right? But when they eliminated that, they basically said, lawyers, you're on your own, go solve this, right? And it didn't get solved. I want to see it, and I'm going to set up a phone call, and I'm just going to say, look, this request number 6, the one that says every document that relates to every other document that relates to every other document, isn't that every document in the world? You can't want everything. What do you want? That question could save the parties thousands of dollars in focusing the discovery and doing. So even when there's an overlap in what you're trying to do, and even if there's an overlap in the expertise, there's a different method being used that assists courts that courts are not in a position to do. Then you add to that the time when you want actually expertise. No judge is an expertise in everything. So you actually want someone who, as I said to a meeting of the cybersecurity task force, we really like people with two-factor identification. I am a cybersecurity expert and a neutral, right? And a mediator and an arbitrator. Because if you bring those two to the problem, you're helping to solve the problem by bringing both the expertise and the common sense of resolving it. So, I mean, those are some of the examples. There are obviously many, many more, but I hope it sort of illustrates how to think about this and how to determine when it's useful. So, Janice, what are some of the skills that people who do this work ought to have, or that judges want to see if people here want to become neutrals? You're on mute, Janice.
That's a great question. And we've had a couple judges actually share that with us. I mean, instead of just guessing what they want, we said, what do you want? And one of the key things they said was superior managerial and organizational skills, great listening, strong listening skills and patience, a little bit of gravitas, that someone who is going to be respected with the highest integrity, who can come into the room and will be heard. They will listen as well as be listened to. Someone who actually, of course, is relatable, that they can talk to, but someone who has a little bit of a sense of trying to go beyond the surface. What's really going on here? What do you, as Merril said, what do you really want? And they're not going to necessarily say that in front of the other side, because then they know what they really want and they don't want to give it to them. So getting to what is it that you want? What is it that you need? And what's the least cost effective, the least costly way to do that, the most cost effective way to do that, are some of the key inquiries of getting to the root of how you can solve some of these issues. I think another thing that's important is not coming in with an entitlement attitude, but more of a service attitude. I know that when I've been privileged enough to do this, I come in with kind of a concierge service mentality. Like, they get the judge for free, basically. I mean, through taxes, but for free. And so why should they pay for me? Okay, they should pay for me because I'm going to go and give them extra, the extra concierge service above and beyond. I'm going to, read everything in detail. I'm going to propose options for them. I'm going to hear what they need. And I'm, yes, ultimately, if called upon, I will adjudicate. But ideally, we're going to reach an agreement amongst the three of us, if you will, or five of us, or however many there are, about what makes sense. And to me, having that service attitude, like you're trying to help the court, you're trying to help the parties, and you are in fact doing that rather than, I'm a judge and full of authority, blah, 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 is a much more well-respected way that people appreciate you. Because ultimately, at the end of the day, they want to walk away thinking they got their money's worth. And they should. And if you haven't added value to their case, why are you doing it? You're not helping. And if the court understands that you haven't added value, that's the last time you'll be appointed by the court. I would say efficiency. And I had at least 3 different judges tell me about the ability to write well, because you're going to be writing a report to the court. And they don't want to read gobbledygook. They want concise, clear language. Here's exactly what happened. Here's exactly what I recommended. Here's exactly why, with an executive summary so they can skip all the details if they want to, but clear, well-written, concise, clear recommendations. So the judge can go straight to recommendations. I recommend that you adopt this because X, Y, Z, done. They don't have to read a single thing. They understand exactly why. And I think the last thing, but far from the least important, was the ability to make the participants feel heard and understood, even if they don't get what they want. That's probably sums up the skills. So the judges aren't asking for much, are they? But the funny thing is, I'm looking at a Zoom full of folks who exemplify those very skills all the time. How is that very different from what we as neutrals do every single day? Mediators are listening constantly. They're adding value, or they never get called again. So these are skills that sound like they're asking for a lot, but they're things that we've already been trained to do, and we are already doing, each and every one of you. So bring this forward to today. What's going on? I mean, we read the papers, we know about the Trump case, but what's going on with with court-appointed neutrals today? Give us some examples of current news headlines where there are court-appointed neutrals right now.
Sure, Janice, if I can just double back to one thing you said, because I want to underscore, okay?
Yep.
Understand that one of the biggest values a court-appointed neutral can do in any setting is help people be heard. If you've got mass torts, one of the things, I mean, there's long been social science research that concluded that people value a fair process as much or more than they value a favorable outcome. And now there's neuroscience research that shows that the parts of the brain that are activated by perceptions of fairness, are the same parts of the brain that are activated by I win. Great. And one of the problems courts have is if you've got a case, particularly with tons of claimants, and particularly with unrepresented claimants, getting them so that they recognize they have actually gotten a fair process, regardless of how it gets decided, is one of the greatest challenges for our legal system. And face it, this is a critical institution in the United States that right now people aren't trusting all that well because of a lot of factors. And it's important for the rule of law that we give people a process when they go to court that answers their needs to feel heard. And it's a critical role for neutrals. Now, to get to Janice's question, I mean, I mentioned the Alabama case. We have a bunch of ongoing cases, some of the mass torts, pretty much any mass tort that you hear about in the news, the Flint water litigation, Judge Judith Levy of the Eastern District of Michigan actually did a program last year, and I'll do this pitch more later, but we'll be doing a follow-up program at our annual meeting where she sat down with Debbie Greenspan, who she's using as a neutral in the case and is also our president-elect at ACAN, to talk about what that case is about and how you use a neutral. And what you find out is the neutral serves tons of roles, both to make people feel heard and to make the process move forward and to make it more informed, and a better process. There's the Madoff Victim Fund. There's the 9/11 Fund is of course a classic example, but that's not a court-appointed setting. But any type of claims administration, Katrina, the BP oil, the disaster, the GM switch case, and a huge number of cases in bankruptcy. And one of the things we're doing is to try to amend the bankruptcy rule, but there are all kinds of things where cases have moved to bankruptcy as an approach to dealing with mass torts. And so then you have the same problem of resolving things in bankruptcy. So, I mean, there are tons of those types of cases, but think more about smaller cases, really. Think more about how you could help dockets deal with backlogs from the pandemic. Could you use neutrals in other ways? If you, for example, set up a roster of neutrals so they're being paid for their work, but then have a pro bono commitment, could you have them do triage on dockets to figure out more effective ways of handling cases? Or use artificial intelligence together with a neutral to try to review dockets and determine ways they can be handled in more effective ways, faster, and make it easier for litigants to practice, or any number of other things. All right, so I've talked about the nation, but of course, as Janice has pointed out, California is its own nation that has nothing to do with the rest of us. So what's going on near you, Janice?
Oh my gosh, what isn't? I will say one of the bigger areas that California has used court-appointed neutrals is in overseeing the reforms that are trying to be made to the correctional facilities. There are, just as we all know, hideous overcrowding and outrageous conditions in some of the prisons. And so much so that Susanville, a small town, literally brought a lawsuit against the California Department of Corrections and won. And there's an entire reform movement underfoot that has involved several different neutrals in trying to, one, investigate conditions that the the alleged prisons that had the problems, and then reporting to the court on, you know, what can be done. You know, when I first heard about that, and I'm not involved in that one, but when I first heard about it, I thought, okay, should we solve world peace at the same time? I mean, it's such a massive issue, but that gives you the kind of scale of, you know, a lot of us went into the law in the first place thinking, how can we make a difference? And I'm sure that each of us in our own way has tried to do just that in our practice. But this is another opportunity when we can help access to justice, when we can help reform a whole system, or when we can even just, like Merril said, take a small case and try to get the parties to envision a future of not fighting. One of the key things down in my area here in San Diego, Southern California, aerospace, medical device defects. I don't know how many of you have seen in the newspaper, it got pretty good publicity, but this was in the UK, the Volkswagen fake admissions where they basically lied and said that they met all these wonderful safety standards and that they had emissions under a certain level, but it wasn't true. It was fraud. And so the UK had a whole huge class action dealing with that because they had over 30 million folks involved with having Volkswagens or Mercedes-Benz or some related car product that were in the relevant time zone. And they used a whole army of special neutrals to make sure that there was claim validation, that the people who were giving the claims with their driver's license and their car, you know, license plate and VIN number were actually real people, not fraudulent bots, which happens a lot actually. And then that they were in the class that they truly owned a car of this make, of this model at this time. And it went so much faster that those people have already started to see recoveries as opposed to waiting 5 and 10 years for some of these court cases to, without help, get resolved. And so that's an example, not down here, but in the UK, but it's the same kind of thing. We have our own. I mean, there's a huge Hyundai class action car defect case that's famous. In San Diego, there's shipbuilding and repair issues. IP and innovation research, the evaluation of information. Think about it. How do you value information? Somebody steals your trade secret, somebody steals your information. What's the value of that? That's a really hard question. One that a neutral can spend some serious time with the parties figuring out versus trying to get a court to decide that, you know, in a 5-minute oral argument. Another example is finance, real estate, insurance. Also a lot of special ed. In San Diego and Los Angeles, we have a lot of special ed, IEP, individual education program cases that, if left solely to the court, would swamp the court even more than it already is swamped. And so a lot of those have been, I think, very appropriately handled by neutrals with special education expertise. You know, they know the laws, they know the different nuances, what's required, what's not required, etc. So that's what's going down in you know, my neck of the woods. There's also, of course, tourism and hospitality, very big. You know, it is San Diego after all. All right, we've sold them, Merril. We've sold them. They want to be court-appointed neutrals. They love us. They want to do what we do. How do they do it? Tell them how to get involved.
Okay. Thing one, join the Academy of Court Appointed Neutrals. Okay. Go to our website and apply to join the Academy. We are doing terrific things. We think to try to advance the industry and also to try to advance our members and try to combine people's desire to get this work with genuine opportunities to assist the administration of justice. We have a wonderful annual meeting every year. Our next annual meeting is March 7th to 9th at the Bee Ocean Resort in Fort Lauderdale, Florida, and we put together a wonderful program, and we just opened it for registration, so people can sign up for that.
Well, and let's just encourage even more, because I'm not ashamed of a hard sell. You need to be there in Fort Lauderdale. No, I'm going to be there. You need to come. You need to join me so we can talk one-on-one about how to do this, so that you can see Deborah Greenspan in person, the Queen of Flint, right? The Flint water case. You have to be there where the action is to know what's going on and find yourself a mentor. And we have them. All right. That's number one. Number two, the day before the annual meeting is in-depth training. So if you're like, I want to do this, but I feel a little in over my head, I don't really know quite yet how to do this, come to the day before for the training. If you can't come to Fort Lauderdale, I understand, sometimes it's cost prohibitive. You're in a hearing already, you're in a mediation already, you have a busy docket. I get it. At least become a member, get the newsletter, figure out how to become part of the next cohort. They have a cohort for new incoming classes of court-appointed neutrals. I'll let Merril actually get a word in edgewise before we're done, but I'm telling you, come to Fort Lauderdale, hang with me. That's it.
Okay. So, first of all, this time what we're doing is a workshop at the beginning of this. It's actually a hands-on experience where we're going to not just talk at people, for training. This is actually directed to both experienced and less experienced people, but it's let's do AI and let's figure out what it is and what it does and understand it, and bring your computers. And let's talk about how to advance the profession and what useful things can be done. We have a really wonderful program. The resources, you have these 2 resolutions that the ABA just adopted. We are in the process of working out how to promote the ideas in these resolutions and how to personalize it, because one of the things about court-appointed neutrals is we have a wonderfully diverse country. It isn't all California, notwithstanding what you heard from Janice. There are the rest of us, and every part of our country, there are similarities, but there are differences. So to make this genuinely useful, what you want to do is really a 2-part. You have a discussion kind of like what Janice and I have had about what this is and what it might be and whatever, to get people from the point, moving from the point of lack of knowledge or mild distaste about court-appointed neutrals to, yeah, this might be an interesting idea. And then you sit down and roll up your sleeves and talk with local courts about what they're facing. And, it's great for me to tell everybody I'm from Washington, D.C., and I'm here to help you, but I found that message doesn't seem to work that effectively. What is much more effective is to have the people who sit with their local courts around the country and meet with people they're familiar with and help them work through ideas. We're working on specific projects in some different places, and I'm trying to expand this to more. We are also an intersection of courts and ADR, and think about what that means, okay? So basically, we partner with dozens of other organizations, both courts, judges, judicial organizations, court staff organizations, ADR organizations. We're part of the Diversity, Equity, and Inclusion Collaborative that's run from the National Council of Juvenile and Family Court Judges, which is an amazing intersection of organizations who are looking at this from a lot of different perspectives. And I see we're running out of time because I could wax more poetic. But get on our website or just contact me. I'll put my email in this and I can point you in the right direction, or can't contact Janice. And I can give you more information. Obviously, we have nothing to talk about, and both of us are incredibly shy. But thanks everybody for your time and interest. I really appreciate it. And thanks, Janice. It's wonderful to be with you.
You too, Earl. And thank you so much for inviting us. We really, really appreciate it. I see some very friendly faces, and I appreciate you coming out. It's been a while since you started this program, Natalie, and I couldn't be prouder of the success that all of you, Jean and Jeff and yourself, have really, really filled a need. Thank you for inviting us.
Yes, thank you so much.
Thank you so much. It's just a thrill. And I'm sure people will get in touch with you. Some questions in here were, how do you get paid for some of this? I know you touched on some of it, Janice, but it's great. And thank you so much. Take care. Have a great rest of your day, a wonderful weekend, and we'll see you next Thursday for another great We'll Work for Food, the New Possibilities Hour program. Thanks again, Janice and Merril. Bye-bye.
Thank you guys. Bye.
So long.
Bye.